Nearly 4 years after one of the worst school shootings in American history, a jury is set to decide whether a school resource officer is criminally responsible. It's day 2 of the Uvalde School Massacre Trial for former officer Adrian Gonzalez. Prosecutors say he failed to engage, distract, or delay the shooter and did not follow his active shooter training to confront the gunman that killed 19 children and 2 teachers back in 2022. Gonzalez has pled not guilty to all charges. They'll go back in the courtroom now. We'll pick up more from this teacher, Stephanie Hale. The defense thinks all of her testimony should be thrown out. They do win that argument eventually here, but let's go watch the end of her testimony now on redirect.
I guess, were you aware of any teachers or substitute teachers using magnets instead of keys to cover up the part where the door would lock so that the door could be open?
Possibly, but I don't think that the school district gave them the magnets for that purpose.
Okay, and so as far as, I think what I hear you say is, as far as you know, as far as you're aware, you don't know that they were doing that.
Yes.
You said possibly, is that something, I'm just trying to explore, is that something that you had seen before? Have you seen these magnets being used in that way at the school?
I've heard of people doing it, yes. I've never physically seen any other teacher at that school do it.
Okay, right, but you heard of it as a practice with some teachers, but you hadn't personally witnessed it or seen teachers do it. Do I have that right?
Correct.
Judge, I'll pass it.
Redirect. Thank you. I just want to be a little bit more specific on information provided to the defense.
Okay.
Okay. Of the 3 things that are up there, saw clouds of dust, you told the grand jury about that?
Yes.
And that was provided to the defense?
Correct.
And you were also asked where the shooter was. Is that correct? Where the shots were coming from? Is that correct?
Here today?
No, in front of the grand jury.
I don't remember.
Would you like to refresh your memory?
Please.
May I approach, Your Honor? Yes.
Okay. Yeah, it says on there.
And so were you asked where the shots were coming from?
Yes.
And did you tell the grand jury?
Yes.
And was that provided to the defense?
Yes.
But you were not asked how the shooter was dressed. Is that correct?
Correct.
In front of the grand jury?
No. Well, I don't believe so. Not in that part that I just read.
Now I want to go back to the questioning that's been occurring. Today's question has been very specific.
Yeah, yes, sorry.
In front of the grand jury, was it very specific?
Not like this, but I don't know. It's a little more specific here.
Okay. And with the Rangers, did they just simply ask you to tell them what you knew?
Yes.
Were you conducting the investigation?
No.
Did you know what was specifically important to them?
No. I didn't think that what I had to say was as
So they asked you to explain what happened? Is that correct?
They did, yes.
And you told them?
Yes.
And when they asked you, is anything else important, did you know what was important to them?
No, I was ready to get out of there.
Was it your job to know what was important to them?
That was subject to leading.
I'll overrule the objection. Go ahead.
I'm sorry. Go ahead. I'm sorry.
Was it important for you to know what was important to law enforcement?
No, it's not my job.
And now I want to go back to those events if we could, okay?
Okay.
Did you hear a sound?
Yes.
And did you attribute it to something that you were familiar with?
Yes.
And what was that?
The dumpster.
And now Mr. Goss's questioning very well could have been a wreck instead, correct?
Yes.
So you attributed it to something you were familiar with.
Correct.
Then you hear what you found are firecrackers.
Yes.
So you hear a sound
Yes.
attributed to something you're familiar with.
Correct.
And according to Mr. Goss, now that very well could have been gunfire at another human being, correct?
Correct.
And then you have a coach, correct?
Correct.
That tells you to, or What is your testimony? Did he tell you to go and lock down, or what, did he say anything to you?
I don't remember if he said anything. I just saw his face and I saw him pull up the radio and...
But at that time,
I knew.
I believe you said to Mr. Goss that you were thinking bailout.
No, when I got into the classroom, the kids said that they were not taking it seriously because of all the bailouts.
Okay.
But I didn't think that it was a bailout,
Oh,
like based on the coach's face, I guess,
Okay.
and everything.
All right.
That never, I guess, crossed my mind.
Very good. Thank you. Pass it with us.
Just look briefly, thank you, Judge. The prosecutor asked you of the three things on here, and we talked about it, that you did say that there was clouds of dust to the grand jury years later, but not at the time, right?
Correct.
The three things, these two things were not given to the defense, and you understand that?
Yes, I do now.
I'm sorry, Your Honor, I didn't hear what the last question was. It may be important.
Oh,
Did you say?
I said, the three things, the two things, you said the three things on the board. I said, those three things, those two things weren't given to the defense. One and two.
Okay, I just want to make sure I heard that.
And just because Mr. Turner asked you, was it important to you to know if it's important to law enforcement? And you said it's not your job, and I agree with you. It's their job, right? But you agree that seeing a man with a gun on your campus is an important detail that you would recognize instantly that you would need to talk about.
I mean, I know that now, yes.
Well, and you would have known that then.
Possibly.
Because I think what you were saying when he was talking was that you didn't think that what the information you were providing was, in the scheme of things, I guess very important. I didn't hear you because you were talking.
Yes, I didn't think that what I had to say was very important. I didn't think that it mattered based on or compared to everything else.
I understand, but...
All right, Stephanie Hale, the end of her testimony. We'll get a break and see what the judge rules. He rules that all of her testimony will be thrown out. Canon Kearney, overall, what do you think of this prosecution? This guy's, the defense is going piece by piece, minute by minute, what he did and didn't do from his perspective. Is this the right fall guy here? What's your take? Is this an overreach, or do you agree with the state of Texas going after this law enforcement individual?
So, Ted, when you have children that you pray about before you go to work, as they go to school, when you have communities of families that look to law enforcement and the individuals in power to ensure that these children are safe, somebody has to reckon with the situation that multiple, I believe almost 19, 20 people died here. That's a big issue, Ted.
21.
So do I believe, 21 exactly. I don't
kids.
even want to belittle.
Yeah.
I don't want to belittle the situation at all. So that's exactly what the prosecution and what the state and what the individuals in power in that city understand, is that if they want to get elected again, if they want to continue to be in the positions that they're in, then they need to take this seriously. And so I think that they're doing the best that they can, even if it is an acquittal for the defendant. But essentially, this is something that the nation is having to deal with all of these school shootings, and this community is doing the best that they can to honor those who were killed for no reason at all.
Yeah, it may change a lot of where we go from here, like the Crumblies did with holding parents accountable for school shootings. How did the child get the gun, et cetera. Now, if you're in law enforcement and you don't conduct yourself properly, you could find yourself at a defense table down the road. Can't occur anything. Thank you. We need to break. When we come back, we'll have that judge's ruling. In Uvalde Plus, we're waiting for a sentencing hearing of Devin Michael, the porn star, sentenced in Vegas. Stay with us. Welcome back to Court TV Live, along with Kelly Craft. I'm Ted Rollins. Good to be with you on a Thursday afternoon, almost-ish, here in the East, where we are focused on Texas. The Uvalde school officer who allegedly failed to confront a school shooter is on trial. The state saying he didn't do enough.
His name is Adrian Gonzalez, charged with 29 counts of abandoning and endangering a child after prosecutors are saying that he failed. That's what they're saying to do. He failed to confront the deadly gunman.
Nearly 400 officers eventually arrived on scene, but he was one of the first to get there. And only Gonzalez and the former Uvalde Schools police chief, Pete Arredondo, have been charged in this case. No one else, none of the other officers who were there for that 70 minutes are facing criminal prosecution.
So the teenage shooter, he was a former student who was eventually killed at the scene, fatally shot 19 students, and 2 teachers, also injured 17 others during this attack.
So we've been watching this morning this testimony, the end of the testimony from Stephanie Hale, the teacher that the defense says blurted out facts that they had never heard, and that placed their client close to the shooter, which changes the game for them.
Absolutely.
And they wanted the mistrial. It didn't happen. They went through the back and forth, finished her testimony, and the judge says, all right, at the end of that, I'll take it all in and I'll make a ruling, and that's where we're at right now.
Why don't we go ahead and go back into court? The attorneys, they're arguing over the testimony from the teacher, Stephanie Hale.
Let the record reflect we're outside the presence of the jury. The witness has completed the testimony. Where are we at on motions?
Yes, Your Honor. After considering the testimony of the witness, we are asking the court to avail us, the defense, of the remedy of instructing the jury that they cannot consider her testimony at all for any purpose in its entirety. The failure to turn over the specific, that specific piece of critical evidence has put us to a disadvantage with this witness, has put us to a disadvantage with our theory, as I've kind of outlined to the court in the ex parte brief that I provided. And we do not believe that, again, the court has denied the mistrial, but we do not believe that that allowing the jury to consider her testimony for any purpose, we believe that it'll affect the due process rights of the defendant and our ability to continue in the defense of the case in the way that we had set it up and prepared for in the first place.
State.
Yes, Your Honor. The accusation yesterday was significant. It gave us significant pause. The 3 very important things were left out. Number 1, the shots flaring up around her. Number 2, where the shooter was, and number 3, the clothing that he was wearing. That gave us significant pause. But lo and behold, yesterday we're able to find out they did actually have the information about the shots being fired up and behind her. The evidence has been developed today that they did actually have the evidence that she said that the shots, I agree, not the gunman, but the shots came from the building and then indicated. So they do have information that she was aware of where the shots were coming from. That does leave, though, Your Honor, still that disturbing point about the clothing not being turned over. We agree that is improper. We should have done it because it was new information. Didn't seem all that significant since we had photographs of the shooter in black. But nonetheless, we believe, number 1, it has all been cured through cross-examination. He's pointed out that she didn't say it originally. The jury is aware of the truthful nature of her conduct all the way, and they weren't ready and prepared to do that. It has not caught them off guard as of now because of the court granting a continuance. Second of all, Your Honor, we believe that if the court does believe some kind of measure is appropriate, we ask the court not to throw the baby out with the bathwater, and that is the only surprise that they're addressing is the black black hair and the gun, and it would be appropriate if the court feels like that caught them off guard and has affected their defense to instruct the jury not to consider that portion of the testimony.
Your Honor, may I respond? Because I feel like I'm getting gaslit with this clothing thing. That is not the issue about black clothes. It is the fact that she said that she saw a man who matched the description of the shooter with a gun. That is the
And a gun.
That's the key issue. It's not his clothing or the fact we know that he was wearing black. And ultimately, I think what the defense, what the prosecution doesn't know about the defense strategy, the court does know. There's things that we could have done and investigations we could have made.
Mr. Goss, I've heard enough. Again, Mr. Turner, you don't have the benefit of the ex parte brief that Mr. Goss filed, and I think you'll probably gleaned issues from the arguments, but there's no doubt that this was critical to the strategy. And I don't think I have any choice, having denied the mistrial, other than to craft a remedy that will protect the due process rights and hopefully avoid any appellate review that would result in this case being reversed. So I am reluctantly going to instruct the jury to disregard her testimony in its entirety when they come back out. If we could bring her back in momentarily, the witness. Ma'am, could you come up to the bench here very quickly? We're going to let you go here in a minute. I hate to talk to people from the bench. You don't have to sit down, just right here. I just want to tell you, you may hear later on that I will instruct the jury to disregard your testimony, but I want to emphasize to you, you did absolutely nothing wrong. It is not on you. And I want to tell you just from personal experience, memories of traumatic events change, are different, or you recall more or less. I had a personal experience many years ago. My wife and I were hit by a drunk driver, and I spent 2 months in the hospital. Apparently they almost lost me in the emergency room, but revived me. And I remember that event very clearly, that truck coming at us and trying to get out of the way. But every time I think about it, it's a little different. And that's because of stress and trauma. So nothing about this is on you. We appreciate your bravery that day, and we appreciate your testimony and being brave enough to come in here, and you are excused with our thanks. Take care. All right, we're going to take the rest of the recess till the jury comes back out, so I think they got about 5 more minutes or so. We're in recess.
Let's go ahead and bring in our guest this hour to discuss. Joining us from St. Paul, Minnesota, criminal defense attorney and former prosecutor, Jack Rice. Jack, great to see you. Good message there to the witness from the judge. What's your reaction?
Well, first of all, I'm thrilled about that. And when you realize the trauma that this event had on this entire community, it was extraordinary. At the same time, when you're trying a case, any case, and a witness has to be brought back in, one of the things you're trying to do is to get them to relive the circumstances. That's more trauma. And so the judge's acknowledgement of that, I think, is incredibly important. At the same time, one of the things that's a bit frustrating when I see things like this is this failure to disclose, partially because do we know that this was already out there? Was there something that the state should have done differently? And one of the problems I always have once somebody testifies is the cow's out of the barn. The idea of saying, hey, you know that testimony where that person got in the box and they said they were going to talk about elephants? Now, I don't want you to think about elephants anymore. I don't want you to think about what they look like. I don't want you to think about how big they are or what they smell like or how much they weigh. So just remember, don't talk about and don't think about elephants. The problem is human nature tells you exactly the opposite. And so it's already out there. And crafting a remedy is great for the Court of Appeals, but the problem is you're talking about 12 people in a jury box.
Yeah.
Yeah, I like that elephant. I'm sitting here. Yeah, I can smell an elephant. Thank you, Jack. On the other
That's what
hand,
I'm here for, brother.
On the other hand, a jury does take into account that, oh, this side maybe did something wrong, right? It is a win for the defense. Yes, the bell was rung, but having the judge then formally tell the jury, disregard everything that lady said. They were there when this thing was abruptly halted and sent home and said, don't come back till Thursday. So it is a win, is it not? They didn't get their mistrial, but it is a win.
It can be a win, Ted, because if we think about how the jury is looking at this, one of the things that they do want, and I found this to be true, and I've tried a lot of cases in my life, is that they want fairness. They want this perception of fairness because they're coming out of their own lives. They're taking a lot of time that they don't have. Sometimes it's financial harm that they have to go through. Sometimes it's just all the stress of going through this trial themselves. And even though they moved this from the original jurisdiction, these people have still felt this from afar because many of us have. So with that in mind, if there's a perception in that jury box that the state did something wrong, that's a notch on their credibility. And so you have the potential that you could say, not only could we not trust them when it came to this one witness, now I'm starting to question whether or not I can trust them on anything that they do. And that is always the fear, because credibility is really the most important thing that anybody has in the case. And if they start to lose it, a jury will look at them sideways. And sometimes once you lose it, you never get it back.
Yeah, credibility is so important, Jack. Good points. We're going to continue to, monitor the situation there and follow this case. It's a very important one with so many victims, and it's just a very tragic situation.
Yeah, we'll get a break now, and then we're also keeping our eye on Las Vegas, where Devin Michaels is set to be sentenced. That is delayed a little bit, we're being told. So when we come back, we'll head back to Uvalde. The next witness will be ready to take the stand. The judge is going to instruct the jury, disregard the teacher, Stephanie Hale, and then they'll get on with day 2 of testimony from Corpus Christi, Texas.
I'm going to ask you a lot of intensely personal questions.
From the crime scene to the courtroom, this is Victim to Verdict.
Everyone has this heightened sense of anticipation.
What a day here at Court TV.
Fireworks both inside and outside the courthouse.
Let the cameras roll.
Now back to Texas, where we have been watching testimony in the Uvalde School Massacre Trial.
Former school police officer Adrian Gonzalez was one of the first to respond to what would become one of the worst school shootings in U.S. history. But prosecutors say Gonzalez could have saved countless lives if he would have acted quicker in confronting the gunman.
Why don't we go ahead and get you back into the courtroom now. The judge is back instructing the jury on a teacher's previous testimony before the state calls the next witness.
But I will tell you, the law mandates that I do this, and I don't want you to wonder why or the need for it, but we need to follow the law, and I'm going to direct you in that regard, and I'm going to expect you to follow it. So listen carefully to this instruction, if you would, ladies and gentlemen. We have just heard testimony, as you know, from the witness, Stephanie Hale. The court, outside your presence, after a hearing mandated by law, has ruled that the witness's testimony will be and must be excluded as a matter of law. Therefore, you are instructed to disregard any and all testimony provided by Stephanie Hale, and her testimony will play no role in your analysis, deliberations, and decision in this case. With this instruction, you are reminded that you are bound by your oath as a juror to follow the ruling of the court as provided. So please remember, ladies and gentlemen, mandated by law, don't speculate about it, don't wonder about it, don't hold it against either side, just follow my instructions.